Hello, everyone. It's Francis Widdowson here. The reason for this video is just to continue with an attempt to provide an overview of the arbitration of the Francis Widdowson case. I did a video a couple of days ago where I made an initial stab at this. Now I've kind of refined my overview so you can get a good sense of the documents that are involved. Anyway, to do this, I'm just going to share my screen with you and to see what's available here in terms of the wokeacademy.website. So for people who are unaware of this, this is the wokeacademy.info website. You can get to this site by entering in the website www.wokeacademy.info. You'll see on the right-hand side, there's a number of posts. And what I'm trying to do is the posts that are about the Francis Widdowson case. I've used the hashtag Francis Widdowson case. Hopefully this will allow these to be located more easily. And I did the video a couple of days ago on this second post here, which is the arbitration decision. And for people who haven't seen that, I just wanted to show you the decision here, which you can just click on this link. And what that does is it puts you into the what's called the Canley site, which is a website with all sorts of legal decisions. And just so you're aware of what I'm going to be talking about is the table of contents. This provides all the information about that decision. Much of it is very interesting in terms of the witnesses, right? So you have the witnesses that were called by the university, and then the witnesses that were called by the faculty association, that's my union, and then you have the decision of the arbitrator starting on 196. This is where the arbitrator dismisses all the procedural grievances, such as the complaints about the fact that I was never given the complaint for the Dirks and the Lindstrom complaints, for example. That formed part of the grievances that came before the arbitrator. He wasn't interested at all in these procedural concerns, but starting on page 239, he did sort of respond to the substantive grievances about discipline. So for grievance number 4, I was suspended for 2 weeks without pay. He found that that was excessive and turned that into a letter of reprimand. And then on page 280, he said that now, because I'd only received a letter of reprimand, the termination was null and void. So this shows that I shouldn't have been fired at MRU, which is a very important aspect of his decision. But another important part of his decision is on page 292, which is about the remedy. And this is where the arbitrator decided that although I shouldn't have been fired, I can't be reinstated at MRU because there's a number of people who don't want to work with me and who have a lot of friction with me. That's essentially what many of the comments were about. And of course, this is an incredibly unjust type of decision because there are numerous people at Mount Royal who are hostile towards academic freedom. And why should those people be rewarded for basically being involved in destroying the academic nature of Mount Royal University? Anyway, this is being appealed, so hopefully we'll have better results when we go into the court system, which is what I think I should be anyway. There are serious problems with arbitrations because, first of all, they're not recorded. So we have no overarching record of what actually transpired. I always wanted the hearing to operate according to the open court principle, but I lost that battle, and then we got into this secretive type of process, which I was really opposed to. So I would like things to operate according to the open court principle so that everyone can see all the evidence that's available. Anyway, so that is the decision, which I'm trying to provide some more information, some categorization, so that it makes understanding it a bit easier to follow. So that is that first post, or the second post, which is the Francis Widdowson case arbitration decision. Then what I've done more recently today is to provide a diagram of how all the documents relate to one another. And I'm hoping that this will clarify some things. What I've done is organized all the various documents into different levels so that it can be more easily understood how they all relate to one another. So this is the original document that I created as a kind of a diagram. And then what I've done is I've explained that diagram, and then I have sort of shown in red how all the different levels of documents relate to one another. And I essentially have organized them into 4 levels. The top, so the most significant or the overarching document is the arbitrator's decision, which was made on July 2nd, 2024. This decision was formulated on the basis of a number of documents, the most significant of those documents being the final submissions that were made in January 2024. So on January 16th, 2024, MRU made its final submission, the union made its final submission, and in that final decision, we finally heard what MRU's case was. So the reasons why it fired me from Mount Royal. And we found out that it was because of 9 tweets and what it claimed was a frivolous and vexatious complaint that I had made. So that was MRU's case. We never found out as to what that was until January 16th, because the arbitrator never forced MRU to particularize its case. So we spent 2 years trying to figure out what that case was, had all sorts of, people testifying to various things, while MRU went and searched into all sorts of nooks and crannies over 30 hearing days. And then finally we had it all narrowed down to what they actually were thinking were the reasons why I got fired. MRFA also made its submission, and then we had the 2 replies. So MRFA replied to the MRU submission, MRU replied to the MRFA submission on January 24th, 2024. So this is the second layer and the second most level of most significant documents, because you can understand that the arbitrator had to rely on hundreds of documents, and so he's going to have some kind of narrowing down process. And these are the final things that the union and MRU submitted. So obviously they would have submitted their most important details, and that one would expect would form a substantial part of why the arbitrator decided what he did. Those final submissions, however, were based upon this level 3. So out of this collection of documents in level 3, this is what formed the basis of these submissions, and these were actually what was put forward in the arbitration hearing as the things to rely upon. And this is what's called exhibits. These were 303. There's 303 exhibits. 108 came from MRU. 195 came from, sorry, that should be the MRFA. So the MRFA, the union provided 195 documents. The MRU provided 108, and that was a total of 303. And then we have the witness testimony. So 24 witnesses gave evidence, and these were people like administrators for MRU, the investigators, The complainants, Lindstrom and Watchman, for some reason, Dirks did not testify. Tim Haney, who was the person who it was argued I had filed a frivolous and vexatious complaint against. There were people, professors who were opposed to my existence at MRU. There was professors who were in favor of the things that I did at MRU, and they had the union representatives, and that was the total of those. So all of these things here, this formed the basis of these submissions that were made by MRU and the MRFA. That's why there's an arrow going up from this level 3 to level 2. I have singled out the most important exhibits that existed from these 303, and these are the investigator reports. And there were 5 investigator reports, and I've grouped these together into 3 categories under A, B, and C. The A category are those reports that form the basis of my 2-week suspension. And this was the Hawkins report, concerned 1 tweet about misgendering fatigue. That was made on February 1st, 2021. The Rents report, which said on the basis of tweets mentioning GL, that's what she said was harassing. This was made on February 15th, 2021. And these 2 things together, the Hawkins report and the Rents report, resulted in a 2-week suspension for me, for Widdowson. B, category B, is the Eichler report, the first Eichler report of the Gang of Seven, what was called the Gang of 17. That was handed down on May 21st, 2021. This concerned many, many tweets and retweets and concerned 6 professors. So there were 17 who were complained about. 6 were found to have engaged in harassment against me, and they were issued letters of warning. And then finally, C, we have the 2 reports that resulted in my termination. The second Eichler report, which was about a complaint that I'd made against Tim Haney, and the Hope report, which is Renee Watchman's complaint. Eichler's second report was October 8th, 2021. Hope report was November 18th, 2021. Anyway, this was a frivolous, for the Haney complaint I made against Haney was found to be frivolous and vexatious. And then for the Hope report, he found that 8 tweets and 1 Facebook post were harassing and also created a toxic workplace environment. And these 2 things together resulted in my termination. So these are also exhibits. These 5 reports are exhibits, but I think they need special mention and also elaboration, because the arbitrator's decision, an important part of the arbitrator's decision on July 2nd, was that he did not do any analysis of the legal reasoning that each of these investigators used. And so what you find with these different reports is the standard of harassment is very, very different. So for example, Eichler, the first Eichler report and second Eichler report, the threshold for harassment. So in order for someone to have been found to have harassed someone, that was much higher than for the Hope report, where the standard was much lower. So in the case of the Gang of 17 report, 1 professor who was not found to have engaged in harassment was a professor by the name of Karen Pheasant. She, on her Facebook page, posted a petition that was demanding that I be fired and encouraged people to sign this petition. Now, generally, one would think that this was somewhat of a harassing action, because she is directly trying to get me fired for an academic freedom, for me, sort of pursuing my academic freedom pursuits at MRU. Eichler, the first Eichler report, found that she had not engaged in harassment because it was just 1 post, and it was something that it was a belief that she deeply held, that I, was a racist and these sorts of things. The one post finding would have meant that in my one tweet about misgendering fatigue, if Eichler hadn't been investigating me, then I would not have been found to engage in harassment of DA Dirks, because I only had one tweet about the misgendering fatigue. Karen Pheasant had one Facebook post that was asserting that I should be fired and that I was a racist professor and so on. But that was acceptable for Eichler and not harassment because it was only one tweet. So you can see the inconsistency there. Eichler as well, if you didn't mention someone by name, it was not found to be harassment. This would have meant that all of Hope's tweets, or I think almost all of them, 7 out of 8, would not have been found to be harassment because I was just, satirizing the MRU anti-racism coalition. So therefore, it didn't really rise to the level that what Eichler was demanding. So this is a very, very important part of what happened to me. And because the arbitrator in his decision did not do an analysis of the reasoning of these different investigators, it means that things are still very, very unsettled as to what constitutes harassment and what is not harassment, because the arbitrator just accepted all the findings of the investigators. But how can that be possible when each of these investigators had very, very different standards for harassment? And that's really what you expect from an arbitration decision, that it will kind of take an overarching view and do the analysis, do the legal analysis that's required. So I think this area of the third level is very, very important, especially with respect to these investigation reports. And that's what I'm going to be spending a lot of time talking about. And actually, I did do a report, which I submitted to the Canadian Association of University Teachers, which gave my analysis of the inconsistencies of all these reports. So that's something that I want to share with you and also talk about in the future. So that's level 3, which, as we see, goes up into the submissions, which then resulted in what the arbitrator decided in those submissions, as well as other things that he considered. The bottom level, or the most general level of this diagram, concerns all the documents that are available. And some of them are my own documents, and those that came from non-MRU sources, those are publicly, they can be publicly distributed and discussed. The others are what was received through production under a confidential arbitration order, and those are going to remain confidential. And those, the reason why they remain confidential is because they never became part of the exhibits. So they were not entered into evidence at the arbitration hearing for whatever reason. And there's some very, very important documents, such as documents involving the union's actions of filing grievances on behalf of Gabrielle Lindstrom, D.A. Dirks, and Renee Watchman that named me as a reason why their workplace was unsafe. I found out this through other documents as well. These are very, very important, but because they involve the union, it's on sort of another stream, and it's maybe be pursued at some later date. But right now, because they were never entered into evidence, it makes it difficult to pursue at this stage. Other confidential documents concern things like the interaction between the investigators at MRU, the people who were doing the investigations, and MRU administrators. And there's a few documents like that. And those are very important because it shows a little bit like there was sort of some discussions that were happening between administrators and the investigators, which really it should be an arm's length process, but for whatever reasons, those were not entered into exhibits. Anyway, so that's explaining that diagram that I had provided. As I mentioned, the arbitration decision, which was handed down on July 2nd, that's going to be appealed because of the remedy, the problem of the remedy, which is that I shouldn't be reinstated. I'm also hoping that part of the appeal is going to be looking at how the arbitrator didn't really do an analysis, a legal analysis of harassment. So my view is that I never harassed or discriminated against anyone. What I did not rise to the level of harassment. And I would like to have a statement from MRU making that statement. I think that that is very, very important to get that cleared up. That, of course, doesn't exist right now because of where we are in this process. And as well, the reinstatement that needs to be appealed, because it just does make, it is just a terrible decision that because people like, Gabrielle Lindstrom, who was the one who went after me, does not want me to return to MRU. Why should someone who instigates a mobbing of another professor, is completely hostile to academic freedom, and is basically a crybaby who goes and does all these things and then says that they've been harmed and all these terrible things have happened to them because of what they have brought about, why should that be what determines whether a person like myself, who did great things at Mount Royal, who encouraged people to engage in critical thinking, was constantly working on engaging with other people throughout Mount Royal University, perfectly happy to work with people who disagreed with me, why should I be the one who's pushed out and other people rewarded for what it is that they did, which was contrary to the academic mission of the university? Anyway, that gives you a bit of an overview of what happened, how all the documents relate to one another, and I will be doing further videos to explain in more detail the various aspects of that diagram. Thank you very much for listening.